Scaife and Urbanski will agree with you today, that's for sure. That was a new one. All right. We are now live streamed on YouTube. Let's go on the record. Court calls case 2022 CF 176, State of Wisconsin versus James Dewey Dunford. Appearances, please.
Joel Urbanski appears for the state, appearing in person.
Attorney Eric Eichhoff appears on behalf of Mr. Dunford. Mr. Dunford and I appear via video, however, from the same location.
All right, and dear Urbanski, before we came on, you requested Zoom, YouTube activated, so we are live streaming. Are we in compliance with victim rights legislation?
We are in compliance with victims' rights. I do not know if there's any desire to speak or if we have anyone joining us today, but the request to be accessed via Zoom was on behalf of the victim.
All right. So we're set today for two things. One was a plea hearing. We've given Attorney Eichhoff roughly 60 days or so to get some discovery and move the case forward. There's also a pending motion to modify bond. It was filed on Friday. The request is reduce the $40,000 that has been posted. The reasons are set forth in the motion. Are we in compliance with victim rights legislation as to that motion?
Our judge, there are two victims in this case. Saw that this motion for bond was filed in the afternoon Friday, and thanks to efforts of the victim witness staff, they were able to get in compliance this morning for purposes of bond as well as a plea.
All right, and do we have anyone who's involved in the Dunford case that's on Zoom or in person in court who would like to make a statement? Now's the time. All right, so let's hear a little bit more then from Attorney Eichhoff. Are you prepared to proceed with the bond motion, J. Urbanski?
I am.
I'd like to get a little bit more detail from Attorney Eichhoff. I have read the motion. I'm not sure when it came in, but I did read it. So, Attorney Eichhoff, give me a little bit more background regarding Mr. Dunford and why 40 is not a reasonable, necessary amount to assure his appearance in court.
Well, judges, the court's aware that we've had numerous hearings. He's been at all of these hearings, and so the court should now have a track record before it's, whereas at the time that it was set, the court did not have any type of track record. And so the bail was set at $40,000 to assure his appearance in court. He has appeared. I'm being proactive here, Judge, and asking this to be reduced to make sure there isn't any issues when it comes to my continued representation. I was hired privately, and there's some concerns that representation may not be able to be continued if some of this money is not returned.
So tell me about Mr. Dunford. I know I've read through the criminal complaint at one point. Obviously, he was employed, I understand it, as a therapist. Is that true?
He was at one time, Your Honor, well before the charges were filed.
What does he currently do?
Your Honor, he is on disability. He does receive benefits from Social Security, disability, and then also VA benefits. He also does some work. He's self-employed in the logistics, the transportation business, Your Honor.
Where does he presently reside?
He lives in Outagamie County, Your Honor. He does own a home. He has been in the Wisconsin area since 2016.
Do you have any prior criminal history? I know I can ask the DA this.
No, Your Honor.
Urbanski?
As it relates to the state of Wisconsin, I see no prior criminal history. I have an NCI one, I just want to review it. I don't all its contents. It's been convictions from my concerns in this case are a few. As it relates to bond, this certainly needs always the amount of that bond is at the court's discretion. There are factors that weigh in favor of the defendant, including that he has no prior criminal history, he owns property in an adjoining county, etc. That being said, we are past preliminary hearing. Appropriate to say that any sexual assault is a violent offense that faces multiple counts or charges with very significant outcomes. Their investigation shows incredible deceit by the defendant. Not only the power and control that he used to engage in the alleged assaults themselves with his patient, also the extent that he lied to her and went to another state to engage in a wedding, and there were wedding photos. Also allegations of potential insurance fraud as it relates to a motorhome that he had. In many ways, the defendant was living an entirely separate, different life and carrying on in that way. Don't know if there are other agencies that will bring any charges. My understanding is there were some agencies that were looking into concerns about the defendant's behavior. As it relates to jurisdiction, I have issued the charges that we have jurisdiction. In my system, I do not see any other county that's engaged in any other prosecution. But I have significant concerns about the defendant coming to court but for a cash bond. Again, the amount of that bond is always at the court's discretion. I will let the court make a decision as to what that appropriate number is. Suffice it to say, I don't believe the current number is unreasonable given the totality and the extremes of his alleged behavior.
Judge, just
hang on 1 second, Attorney Iko. Help me understand. I understand the charges here. I presume we have 4 counts involving victim 1 and then a theft involving victim 2?
Correct. The theft is that he had stolen the file from his employer. That file was victim 1's.
Okay. You mentioned the second life that he was living. That's in connection with some other misconduct or this case? The panoramic, so to speak, at least from the state's perspective.
I would say that it's this case. There are some other aspects of deceit that came up in the investigation. Defense has the discovery. It's voluminous. I don't know how far they are, but as a result, I anticipate he's aware of allegations. And they deal with financial issues, claiming that there was an RV that was stolen when it was never stolen and getting an insurance payout for it. My recollection, there may also be something else concerning some benefits.
Mentioned some kind of wedding.
In this particular case, the defendant and victim actually went to another state and engaged in a wedding, the two of them. Photos were taken, etc. The defendant was shown those photos, used to identify himself as being the person in the photos, is my recollection.
Okay. I was trying to put the constellation of facts together, as I'm obviously unfamiliar with the defendant. All right, Attorney Eichhoff, so here's the other question I would have. I understand the representation issue. But let's presume for a second, and I've not ruled, I'm just asking questions, but what's the stopping point relative to this? Are you asking me to lower this to 10,000, 20,000, and what happens 2 months, a month from now when you get through the discovery? I'm trying to get a sense of what we're dealing with. One, to just understand if there's going to be multiple bond motions, because obviously defending charges of this nature is complex. They're serious charges. 4 Class F felony, F as in Frank, charges against the defendant. So I'm just trying to get a sense of of how you see this playing out. Perhaps is an option for him to petition for the appointment of court-appointed counsel. You serve in that capacity. I'm just asking, because you based the bond motion on counsel, and that makes that's, maybe a little bit more non-traditional than I normally see. But I understand the appearance history. I do get that and understand it. Listening to the DA, I have my concerns. So you're free to respond however you want to respond.
Judge, a couple things. First, he is monitored by GPS through the pretrial services. The court's received records received reports that there hasn't been any violations. So I think that's weighs in our favor. In regards to the wedding, at the time of the wedding, he was no longer licensed as a therapist. And so in November of 2020, it's my understanding is when his license was either expired or lapsed. And then finally, Judge, in regards to the bail modifications, we're asking for half. And so if we were to reduce it by half, and so return of $20,000, we believe that would be sufficient. Obviously, the court has to determine what they believe is appropriate. Depending on what the court decides today, the court reduces it by 5. There may be another bail modification requested in the future. The court reduces it. The more the court reduces it, the less likely any future bail modifications would be requested.
All right. Victim 1 lives in Sheboygan.
No, but
Plymouth, Your Honor.
Sheboygan County.
County.
I should have said county. Okay. All right. So this is one of those challenging moments. They all are when you deal with cash bond. So my sense is this. PA repeated it. I think it's correct. Obviously, the amount cash bond falls within the discretion of the court, applying the factors under Chapter 969. This is a cash bond case. I don't think there's any question, based on the nature of the offenses and the information offered by the district attorney. Cash bond certainly is needed in a reasonable basis to believe it's necessary to assure defendant's appearance in court. Factors, of course, that way into that decision have already been, the decision's already been made, but sort of have to start and begin with that premise. And I think with the nature, number of gravity of the offenses, type of offenses, and allegations in the complaint combined with what the DA has described, concerns regarding some other collateral behaviors, whether they be other acts or panoramic, this case. There is no prior criminal background, which I think is significant, although the charges, again, are so serious. And when we look at setting cash bond, what considerations the court looks into, and we do look at the nature, number, gravity of offenses, whether they're violent in nature, and I think any time sexual assault is alleged by its very nature is violent against the will and consent, or otherwise statutory nature, I think can fit that category as well. He's been bound over, as the state has noted. He's, and maybe Deanna Romansky can clarify, but these are allegations related to a relationship dating back to our time period is gonna be somewhere between October of 2020 and January of 2021?
Yes, the allegations back as far as October 5, like July 1 of 2020. Most recent allegations stem January 24, 2021.
Okay, and the ones you charged are the ones that are here?
Yeah.
What I'm willing to do today is this: I think it has to be a significant cash bond. But I think 30,000 is a significant cash bond. I'll agree to a partial reduction, 40 to 30. I'm not doing the anticipation of more motions, but the legal fee issue needs to be addressed, and I just explained to Mr. Dunford other options he has, whether Attorney Eichhoff wants those options or not is a different issue. But I just raised that because I can see this coming again. The 30,000 does a couple things. One is it's still an astronomical amount for anybody to post, and to lose. And we're dealing with numbers. State, I think originally from the minutes asked for 75 grand. I'm certain defense probably asked for something different. He has no prior criminal history, has appeared in court, which is what we're talking about. I have my concerns based on DA Urmansky's recitation. Not that I'm not considering Attorney Eichhoff as indicated. But I'll reduce it for now because it does give us some time to see and for him to establish further pattern of appearances in court and so on. As far as he will remain on the GPS, those conditions will remain in place. I think all other cash bond conditions will remain in place. I'm not seeing any allegations of any AODA concerns. Am I correct here, Mansky? As long as we're looking at the bond. So I will agree to reduce it on those, with those conditions. I think 30,000 still is significant for just about anybody. Amount of money to post, certainly a lot is at risk. And we can, if we have to address it, the defense can bring another bond motion and deems appropriate, and whether I'll grant that or not will depend on what's said then. So we'll see how things go. But I don't think the amount certainly isn't de minimis, and I still think it remains within a reasonable range to assure his appearance. I am concerned, and perhaps the state will have more information as well at that time regarding other collateral matters that may, in other jurisdictions, I don't know, more information always is helpful. So I'm granting in part. I'll ask, it's the clerk, I assume we'll have that bond. I don't know how that will work, Attorney Eichhoff. You can work with the clerk's office, but we'll have the bond scanned to you in your office, and you can have Mr. Dunford sign the bond. Hopefully.
Thank you, Judge.
All right. So moving on. Yes, I would note Mr. Dunford is in compliance with data reporting. I mean, all those factors weigh in the favor and support the court's decision and analysis. We'll see where this goes. That then takes us to plea hearing. Obviously, the case is not resolved. The DA referred to voluminous discovery, so Attorney Eichhoff, where are things at from that perspective?
Judge, it appears that we're just waiting on one more piece of discovery. The state sent when they did send discovery, they put a small note on one of their cover letters that says that they have some phone extractions, and if we would like to get those phone extractions, that we needed to send them a very large thumb drive or external hard drive. We have done that, so we are just waiting on to receive that from the states. Now it's 112 gigs, and so obviously we need a new date, and so I just asked that the court take that into consideration when giving us a next date. Does the court know when they are scheduling next dates? Because looking at my calendar, I don't know if I'm available before September, given my trial calendar and my limitations in my calendar in August.
Yeah, I'm not working off a standard date. There's nothing standard right now for a variety of reasons that you really don't need to know. All of which relate to just congestion and craziness. Here, Mansky, time-wise, this victim expressed the interest relative to German's certainly due process, getting through the discovery. The state's acknowledges voluminous is critical. I'm not necessarily against September. That's not far from now.
Neither victim has raised any objection to adjournment.
Okay. Does the state have any problems with setting this into September?
I don't, given the nature of the detailed discovery. I have now to see if that thumb drive has arrived. Bring that around is not going to be a significant challenge. I just want to make sure.
11:45, September 15th.
I'm sorry, one more time, Your Honor.
September 15th at 11:45.
Will it be via video?
You can always, defendant has the right to be present. It's a status. If he wants to appear by video, that's fine.
Yes, Judge, that works for my calendar.
All right, and then that's what we'll do.
Judge, the last thing that I wanted to mention is the return of some of the property that was seized during the search warrants. I've reached out to the state a few times. I understand that we're all busy. I'm hoping I don't need to schedule a hearing on the matter. But if, how would the court, I turn to the court for some direction. Would the court ask that I file something since my requests are going unanswered?
I think I can solve this issue, or at least largely solve it. I spoke with the primary detective this morning. He advised that cellular phones can be released. From his perspective, law enforcement has what they need, and since the defense is making the request, I have no objection to the release of those cell phones.
Thank you,
Other
Judge.
items or material, that may be an issue, and Attorney Eichhoff and I can talk about it. If he needs to file a motion, that's fine.
Thank you,
Right, I mean,
Judge.
the proper way for me to get involved would be by a motion on, I always forget the statute. I think I've got one this afternoon. But that would be the proper way to bring before the court, but the DA is indicating the cell phone can be released. And if there's anything else, to get a hold of him, if you can't resolve it, bring it by motion before me.
Thank you, Judge. I appreciate the state looking into that. Thank you.
All right, anything else from DA Mansky?
No.
Nothing
Anything
else.
else from Attorney Eichhoff? Okay, thank you. We'll go off
Thank you,
to
Judge.
Mr. Church next.
Your Honor, I need to run to the restroom real quick.
All right. Oh, it's Yeager. Is he here? When did he take church? Always have church?
I'm here.
At some point have to bail out to cover TP.
Scaife gonna be here?
He just doesn't have the history as a
What time is your TPC?
11:50.
Okay, we'll do 10 Aiken next time. I have an idea on that, so. Do we need, there's Yeager. All right, let's go on the record, please. Oh, he's not on yet. Recorder per still not back. Let's let him come back. What a day, Jeff Yeager. What a day.
Yeah. Believe me, mine is worse, Judge.
stacks up too much. I've been trying to look at my calendar to remove noon hours. Gonna be hard to do.
We can cover 6 places with 5 bodies.
Well,
I know.
Yeager's has his application ready for the DA's office.
Why?
He's always wanted to be a prosecutor, he tells me. Obviously, you didn't hear me.
Normally I have a comment for everything, but I can't come up with one for that. I heard you.
Yeager, this is, I broke the news to my wife that I'm likely not going on vacation, and I'm not sure I'll be around to take my daughter to college, because we're gonna be, Escape and I are gonna be in jury trial.
Oh, boy.
The goal is to turn all my CFs into FAs. Family case. See, Yeager got that one.
Yeah,
Right.
yeah.
All right, let's go on the record, please. All right, court calls cases 2021 CF 625, 2022 CF 233, State of Wisconsin versus Dwayne Eddie Church. Appearances, please.
State appears by Grant Scaife.
Dwayne Church appears in custody on Zoom and by attorney Jeffrey Yeager on Zoom.
All right, so this matter is set. I think these were intended to originally be status conferences because Mr. Church did not have counsel. Mr. Church, you now have counsel. You're able to hear me, sir? You've been watching all these activities this morning. I appreciate your patience, by the way. So, Attorney Yeager, I think we need to do the same thing here, set out a prelim. I don't believe we have done that yet.
I agree. Need a prelim on both cases, and I'm going to meet face-to-face in person with Mr. Church this afternoon to talk about
right,
prelims.
Mr. Church previously waived time limits. Okay, so he was on a warrant, came back, and he had not yet had presumably a prelim in the 625 case. Is that correct? Whoever's here for the state.
That sounds correct.
I think it's correct.
All right, so Attorney Yeager, if you're going to meet with Mr. Church, is there a potential, are you thinking there may be a potential for waiver depending on where things are at?
I think there's a potential, yes.
So do you want me to try to schedule 2 prelims now, give you a chance to meet with him, set an additional status, maybe at the end of the week? You're here for a preliminary hearing on Friday at
3:45.
3:45. We could always do a status, Mr. Church, and if he wants to waive, we could do the waivers then.
That's fine.
Work for the state?
Can you say that date again?
This Friday at 3:45.
Okay.
And that's for status, Judge?
For now.
Okay.
But if you decide to waive prelims, I'm looking, EDA Scaife, I'm not very good at saying that. We do have a victim rights in 2022 CF 233 as the victim exercised rights are we in compliance.
are in compliance. There's no rights as exercise as it relates to, no.
So Attorney Yeager, maybe what we'll do is just put it on for a prelim hearing Friday with the understanding that if it doesn't go to waiver, we'll set it for a different date just so we're in compliance with victim rights laws if there's any notice that goes out to the victim. Does that make sense?
That's fine, Judge. Both
You
cases,
know,
right?
Attorney Scape, maybe if they have an exercise, but I just want to make sure there's no surprise and I don't want to be held up on waivers so we can get waivers on Friday.
Well, if there's not going to be a prelim on Friday, could we just have it set for a status, in case, because I just don't want our office to subpoena people because it's set for a
No.
prelim.
Here's what we do. We schedule it as a prelim. So there's notice under Marcy's law unless you're not concerned about that.
Yeah, I guess if the court's more comfortable doing that as far as for notice purposes, I suppose we can do that. I'll just communicate that we're not going to be subpoenaing people to our office, so we're not having people show up.
Right. Attorney
Okay.
Yeager, are you in agreement with that? Just so
Well,
we
then-
can have,
Then we should just set it for status on Friday, I think.
okay? I just don't want to run into a problem with Marcy's law, but we'll just do status then.
Well, status/waiver, does that get us clear?
Yeah, why don't we do that? Status
All right.
slash waiver or something like
That
that.
works. Status/preliminary hearing waiver. If he doesn't waive, we'll get the officer subpoenaed and set the prelim thereafter. Attorney Yeager, do you continue to waive time limits on behalf of your client?
Yes,
So all time limits on the preliminary hearing remain waived. Mr. Church, Attorney Yeager's going to get a hold of you this afternoon. So Friday is either going to be a preliminary hearing waiver or we'll finally schedule your preliminary hearings in these two cases. All right, sir? And otherwise, we'll have status and figure out where things are going. All right? I think we're all set then. Thank you. Go off the record. All right, let's go on the record. All right, court calls cases 2015 CF 754, 2016 CF 10, State of Wisconsin versus Bradley Tenhaken. Appearances, please.
Lemansky appears for the state, appearing in person.
Mr. Tenhaken appears via Zoom, as does his attorney, Michael Varelli, from different locations.
And Attorney Rufo appears on behalf of the victim in the 2016 CF case.
All right, we comply with Marcy's law.
We are in compliance, Judge. There are victims in both cases. As noted in one case, Attorney Rufo provides representation. In both cases, we are compliant. I do not know if we have anyone outside of Attorney Rufo joining us, or if anyone desires to speak on victims.
All right, so we have a status, we need to set a trial, and we need to get a decision out, and I apologize. I've, in the midst of completing my own work on this case, and unfortunately, due to just chaos, it's not yet ready to decision, but I do expect I can probably get it done in a week to 10 days. My sense would be to set this out for a trial scheduling conference in 10 days when that decision has been issued. Does that work for the state? Does that work for Verley?
Yes,
Work for Rufo?
Yes, this speaking frankly, it depends on your decision.
That's a nice way of saying it. Well, there's a lot there, and I did do a lot of work. I mean, there's just a lot here, and this is as challenging a time as I've ever been involved in my 6 years. But putting that aside, if we set another status in 10, and then we can set a trial date, because you'll have a decision, and then we can also deal with what word joinder would take us at that point as well, because that's still pending. And it is what it is. So my hope would be the latest next Friday. We have Attorney Scaife still with us?
I'm here.
Is Tershner going?
That would be my case. I'll be meeting with the victim as soon as potentially this afternoon. There is still a possibility. I would hope that if it does proceed, we would have Friday afternoon available.
Okay, good. We do 1:15 or thereabouts on July 8th.
I'd ask that we look at 1:30 or later, just so I can attend the meeting.
That's fair. 2:30 on July 8th by Zoom.
Works for me.
That's fine.
All right. We'll just set it out and we'll do that as a scheduling conference decision. If I don't do it in writing by then, I will have an oral decision on the same day. But you'll have a decision on the 8th. We'll also do with Joyner then as well. All right?
Very good.
Thank you very much. We'll go
Thank
off
you,
the record on
Judge.
that case.
Hey, Judge, same Zoom information then for that day?
You'll get new information. They'll be downloaded.
Very good.
Yep,
Thank
it
you.
changes week to week.
Okay.
Thank
Can I be
you.
included with that information? I never get the
Earl-
information.
Attorney Burley, if you want to email my judicial assistant, you can send it to him directly, as
Okay,
long as you authorize that.
I'll do that. Thank you.
Okay,
Thank you.
thank you. Off the record. Go on to Scaife. Yep. And I think I saw Casey Hoff. Let's go on the record. Court calls case 2019 CM 918, State of Wisconsin versus David John Davies. Appearances, please.
It appears by Grant Scaife.
And Casey Hoff appears along with Mr. Davies, who appears by Zoom from my office. Good morning, Your Honor. Excuse me.
Yeah, and I apologize certainly we've had some interesting hearings this morning. So we have a motion pending, which the state's going to need to address. We have two motions pending. So where this case is at, my recollection is we had, and I think it's relatively accurately set forth in the defense motion. We have this extensive motion that was filed. Part of the motion is suppressed. I don't recall what the happened with the timing on that, but it was filed by Hoff, am I correct, January 4th?
Yes, Your Honor.
And the state was ordered to respond. I don't believe the state has ever responded. We then had a hearing. I believe Attorney Stewart was here. And I had prepared, I'd read through things, but the state had not opposed or challenged defense motion to suppress, nor waived. They were under briefing orders, I recall, due to the nature of it. And nothing was filed. Attorney Stewart, I think, basically was the messenger. Am I correct, Attorney Hoff? I mean, I don't mean to use that, but I don't think he was here as other than just sitting here as a representative of the state.
Yeah, I mean, he did make some acknowledgments that the court had the authority to order briefing, that the state didn't brief. But yes, he was there. He was the representative.
And so Attorney Scaife, I know regretfully May not be the first time that we're going down this road. But I currently have no response, no motion for leave based on cause or otherwise. Now I have a motion for basically a summary disposition to grant the motion to suppress based on the absence of any response from the state. Now, we set a status conference, and I believe I can go back and listen, but I don't know that it's necessary. Is that the court, the concern is being put in a position on a motion to suppress when involved, and I have to look back, video and other things, Attorney Hoff, it's quite a lengthy motion. But without opposition, what does the court do? And if the briefing deadlines aren't followed, what does the court do? State obviously had its concerns regarding one of the prior ADAs who I think was here at or about the time this motion was filed. I think we can all agree with that, probably even Attorney Hoff. I believe this was Attorney Hira's case at that time. But I don't know if the goal was to see if a resolution could be reached, where this is headed.
Judge,
And I still, go ahead.
I was going to say, as I laid out in the letter, I did have a meeting during the first week of April with DA Ermansky and DDA Scaife and ADA Stewart in DA Ermansky's office. I know that the DA's office is very busy, so I don't know if, with the benefit of some additional time, there was a proposal to potentially resolve this that was made during that meeting. And obviously, I know the court doesn't get involved in plea negotiations, but I don't know if, with the benefit of a little bit of additional time, if we might be able to resolve. It was my understanding that I was going to hear back the following week. This was early April. I didn't hear back. Again, I understand everybody gets busy, but I don't know if with that additional time we might be able to reach a resolution. I know the court at the last hearing, at least according to my notes, made reference that just given the amount of time, we even sent as defense a follow-up letter saying we haven't received anything, so we can't reply. My recollection was that the court said no further briefing would be allowed by the state. And then we were discussing the issue of potential forfeiture or waiver. As a matter of trying to settle the case, however, I went back to the DA's office to see if we might be able to reach a compromise, because I know this puts the court in an awkward situation. And again, I don't know the status of that. My recollection was the ball was in the state's court last I heard. I'm happy to continue speaking with them if they would like to, and see if we might be able to resolve the case.
Well, the other challenge was, regardless of the case was last before me, I don't believe I had any motion from the state for relief from any orders. I had no response from the state. And I gave the state the opportunity to, I believe, file something if waiver wasn't appropriate. I believe that's what happened, although I can check the transcript. So we could put in some kind of posture. Now, the defense has responded with a motion to dismiss, basically, summarily. So now that's on the tab. And perhaps that's what should have happened at the last hearing, but in light of the circumstances facing the court, he's facing the DA's office. Or wanted direction from the state to file, I wanted the state to do something to tell me where this heads and whether there'd be an objection to what I was saying. Attorney Hoff, I have to tell you, I don't remember telling the state it couldn't file a brief, but I probably certainly would have commented that any effort without absent, I think that I was looking at the state to tell me what the remedy is for what they've done or not done, the case may be. And I was expressed at that hearing that I not want to be put into the position of reviewing a motion to suppress, read the authorities, and rule when there's no opposition to the motion. It puts the court almost against the defendant in a strange sort of way, particularly since I ordered it. We could have done an oral argument. That's not what I ordered. Attorney Hoff's briefs are quite extensive. I guess the other question I have now, I'm just looking at the charges. Is this a third or a second? Or is it a second on the one count and a third on the other? It doesn't make sense to me.
Do you want me to speak to that, Judge, or did you want
Yeah,
to?
sure.
My understanding is it's a third. I think it was incorrectly charged. I know at the beginning of this case, I believe that there was a pending OWI in branch 3, which Mr. Davies subsequently resolved. So I think this is a third, but it's erroneously charged at least on one of the counts.
At least if one of them remains that way, correct?
Right.
So, Attorney Scape, one other thing, are we in compliance with Marcy's law? And there is also a disorderly domestic.
As it relates to that, yes.
All right, so, you know, this, and Attorney Scape, I'm not even sure what took so long to get the briefing, but I don't think it matters. I mean, this suppression hearing was a long, long time ago. And we had scheduling conferences, I think it was getting the transcript. Then, you know, obviously we were all in the middle of craziness. There were thumb drives, there were all sorts of stuff that went on in this case. I don't know if there was a delay on the court's end. We had a number of trials last summer. I just can't tell. It doesn't look horrendous from the court's perspective. We had 2 60-day intervals. And again, I don't know if it was at the defense request or the state's request. I can't tell. But we're here today on June 27th, 2022. So Attorney Scape, the defense has now moved to close on the motion, is asking for summary disposition, grant the suppression motion. The state still hasn't filed anything that I'm aware of, nor has the state given the court any guidance on how to deal with the state's failure to comply with the court order. I think the ball's in the state's court to respond. Probably no, well, it's now different because now I have a motion for summary grant of relief. So, I don't know what the state, I can set a briefing schedule on that, but I only have a response to the suppression motion. I would suspect that that's what is appropriate, however. I don't know that defense motion is inappropriate, and again, I don't know that it's incumbent upon the court, in the absence of an objection to a motion, to do anything.
I don't know. I mean, I have never been in a position where where we've had a summary judgment motion in a criminal case for a specific issue like this in a criminal case. Even if the court were to rule that the summary judgment motion is not appropriate, we're back in the main issue where we didn't file a response brief anyways, and the court's still at the same intersection in which the court doesn't have a response from us on a suppression hearing. So, that's where it all would lead to. So,
Well,
I know I know there was preliminary discussion where we spoke to Attorney Hoff about amendments in this case, which would be to resolve the case short of dealing with all of this. And, but that would, of course, require potentially the court to find that appropriate because the statute requires the court to do that. Now, is this a case where that would be potentially applicable? Maybe.
And Judge, just to be
just to be clear, Attorney Hoff's motion is not titles of the motion for summary disposition, but what I think he's simply asking for the court summarily grant a motion to suppress as a sanction for the state's repeated noncompliance under 80503. And he's going through 97211, I believe, to get himself there, among other statutes. Yes. Now, there's interesting law on that area, but it is what it is. So I don't know what to tell you. And if the state's gonna plea bargain this, the manner you are, which would involve a reduction of an OWI charge, you are correct. We'd be under the statute that it sets forth a standard for that. I don't think it'd be fair to even comment other than to say that in OWI cases, that chapter 967.055 restricts the state's ability to downcharge, but that's all I can say.
Right, it just,
As Attorney Scape has indicated, and I know you're not asking me to do anything more than that. I'm cognizant of that. So, the state still hasn't told me, I think you just have to respond now to either, the state has done nothing, that's the problem. I'm not being critical of Attorney Scape, Stewart, or otherwise, but Attorney Hoff's motion, I think, is historically on point. I don't think he's, not that I would suggest he would take liberties, but I don't think anything in the chronology is not true. At least based on my initial review. I think the state has to tell me what you want to do and who's going to do it and when, so we can bring this matter to an end, one way or another.
And Judge, I'd be happy to speak with the state if it's still open to talk about potential resolution, if they would like to do that. So I know the court doesn't get involved in plea negotiation. I'm not asking the court to. I think there's a basis under 967.055, but I know that's a discussion that perhaps Attorney Scape or whoever is in branch 5 and I would have to have. So
What does the state want to do?
it's hard to, well, for a couple things. So I know the notes here say that the hearing back in March of 2022, and we failed to file a response brief. My notes, at least from Attorney Stewart that I see here, reflect, I think, what Attorney Hoff had noted, that that the court said we're not filing any more reply briefs or we can't supplement it. So that's the court's, or not even supplement, we can't file anything because we never did. So that was the court's order, at least from March of 2022. So that leaves us to Attorney Hoff's secondary motion. Is the court can the court just summarily grant the motion? And the court's hinting at that it wants a response from us on that. The problem is, even if I were to come up with some sort of a theory where the court can't do that, we're then left in a situation in which the court now has to make a decision where there's no brief from us. And I don't know the answer to that. I also don't know the answer to whether the court can grant, not summary judgment, but the court can basically find in favor of the defense if the state doesn't respond. I don't know the law on that. I don't know if there is a case on that specifically. I would imagine if there is one, it would be citing an Attorney Hoff's brief. I haven't gotten a chance to look at it. I saw he filed that today. So I don't know if the court wants me to respond to that to see if I can find something. I guess I can try to do that. Otherwise, the court wants to put it at a status state to see if amendment is appropriate in this case, given the circumstances, which, obviously the circumstances are what they are at this point, on June 27, 2022, as it relates to this case. Now, the public interest, of course, always has to be considered by the court because the statute directs the court to do that, but we are where we are too.
Right. I mean, the problem, and I have to listen to the audio. The problem is that the court didn't create the problem.
No,
And-
it's the state's fault. I mean, the state didn't respond.
Right, but to say, and I'd have to listen to the audio, but when we had the oral ruling date, and Attorney Hoff had sent a letter saying, hey, by the way, they blew the deadline, which ordinarily the hope would be that someone would see that and bring a motion, describe the circumstances under which that happened, seek relief from the order. That never happened. And so I'd have to listen to the audio, but again, this is a tough spot for a court. They did nothing, and I believe Attorney Stewart wasn't in a position to argue it that day either, even if that's what we would have entertained. There was no one even prepared, I don't believe, and Attorney Hoff can correct me, but I think Attorney Stewart came in cold on it. I mean, he's, at least I don't think he was prepared to argue it, and maybe I am incorrect, and maybe I would have not, I obviously wanted a writing. If you look at the Attorney Hoff's brief is how many pages? There's unpublished opinions, there's a whole bunch of stuff. And I think that's where it came, the court was sort of at a loss as I am now. What does the court do here? Particularly with the legislature's dictates on OWIs, what does the court do? And I'm troubled by it because we're now seeing in June and we still don't have anything, motion for relief from the state, anything, or even any guidance to the court as to what should happen. And we're no better off than they were in April. I think the state needs to do something. Now, the question becomes if we blow another deadline. I think Attorney Hoff has cited one case, and I did not have the chance to read it. He's filed his motion yesterday, which I do invite Sunday filings, to my chagrin many times. But I do believe he talks about somewhere in here, as a general matter, courts are not to act as an advocate nor develop arguments for the parties. I'm not sure that's what we're here, but then it goes on to, he just generally cites proposition that a party doesn't respond, the proposition is deemed conceded. Whether that applies here or not, I have no idea, but we're now 5 months past, or 4 months past, at least 4, almost 5 months past the state's original deadline. I think the state could have done a number of things, but it's well within my authority to order the state to file a brief when we're dealing with, with all due respect to Attorney Hoff, really extensive filings. I don't know how the law could be otherwise, and I think obviously it's my order. I think when can the state file a response to Attorney Hoff's motion?
So what would you like a response on as it relates to the motion you filed today?
Yes.
Okay.
Obviously, so here's the problem. You blow the one deadline, and you continue to blow it through April, and then, and Attorney Hoff, you tell me, and I can maybe get the transcript, but I was loath to suggest to the state what its remedy should be if it had one.
I think that's accurate, Judge. I think what you did indicate was that you're not allowing them to file a brief in response to our brief on the motion, but that you wanted us to, or you wanted the state, I think, to see if there was an argument, see if we can meet and confer on a forfeiture waiver issue. Obviously, the way I framed my motion wasn't necessarily I guess in a way it's a forfeiture. But so I just collected the case law that I could find on a motion for what I titled summary grant of relief. And I think the court has a lot of discretion in that particular area, including but not limited to up to dismissal of the case. We don't actually ask for dismissal of the case. We ask for a summary grant of the motion to suppress, which may end up, if granted, in dismissal of the case, but that's the remedy that we were seeking.
Right, and I mean, in fairness to the court, when I have a deadline that's been blown, a letter reminding the state it blew its deadline, and then going all the way up to oral argument with nothing filed, I don't know how I can accept anything at that point in the absence of the state doing something. Even perhaps asking for reconsideration of the decision or order no more filings because the state has a right to file. I don't know. Again, that was the whole point. That's why I was uncomfortable. But I don't want to start arguing for the state. Well, if you want to file a brief, this is what you need to file with me. I've done that in the past. That hasn't worked out very well either. So I think the answer is you have to file a brief in opposition to the defense motion and whatever else the state deems appropriate along with that. And Hoff gets a chance to reply. But this is going on a long time. I know you have no staff, no disrespect intended, but there are staffing limit challenges ongoing. And I think the state needs to provide a reasonable deadline by which it can respond.
So we're going to be responding to Attorney Hoff's motion filed today, just to be clear, about whether the court can summarily grant what Attorney Hoff is requesting as far as we didn't respond, so the court can just make a finding on that and say that we defaulted we basically conceded our position.
Based on the grounds that Hoff has set forth, however, he calls it summary relief, but it's essentially a motion for sanctions, as I read it.
Okay. All right.
Attorney Hoff, it's under 80503 is one of the primary grounds for it. But the court should just simply summarily grant the motion.
Right.
As one of the remedies available to the court in this circumstance. Yes. So the answer is yes, Attorney Escape, but I want to be careful. We're not. Hoff's motion also goes to the state's overall conduct relating to the failure to comply with previous court orders. So it covers all of it, from cradle to grave, so to speak, of the history of this. So I don't want to suggest you only have to respond to some specified portion of it. He covers everything in it.
Okay. I mean, whether there's, as far as a request, for good cause for a reason why we didn't file, any sort of a response brief or anything like that. I don't know if there is a good reason for that, Judge. That's just to be honest with you. I don't know. Wasn't on the case, wasn't on any of the previous hearings, so I'm not sure.
Well, and that this is where we were back with Attorney Stewart. I don't want to make comments on things because until the state does something, it's just all nothing. Nothing from nothing's nothing. And now we're in June. And perhaps there are reasons, perhaps there's not. But we had radio silence now for a period of, again, boy. Attorney Hoff, is it 2 months?
I think the last hearing in this case was March 16th, if I recall correctly.
Right. And I think even then, and I can check the transcript, but what the result is, under this circumstance, the state was asked to brief and address. Am I correct, Attorney Hall?
That the last hearing addressed what was supposed to be briefed?
Well, that the state was supposed to give the court direction to address the circumstance. Well, they were supposed to discuss a briefing schedule to discuss the circumstance related to the state's failure to respond.
Yeah, my recollection is that the court, I think, wanted the state to go first. I think the court may have made a comment such that, you know, Mr. Davies shouldn't have to pay for additional research on this when it wasn't his doing. I think the
Yes.
court wanted the state to go first, and then if we had to respond, potentially we're going to come up with a briefing schedule on that. And so I went to try to, I guess, communicate about that issue. And again, I realized they, you know, their staffing issues. I just didn't hear back. So I don't know what to say beyond that.
All right, so Attorney Scape, I think that's where we're at. State needs to file something.
Is what it is.
How much time?
I don't know, Judge. When does the court want it back on, want me to file it by?
I have no idea what's reasonable for your office. I mean, I'm not trying to play games, but if I say 30 days and you need 60, I say 60, you need 10. You know, I understand the current problems. I suspect this is all one giant interrelated problem, but I don't know that.
As for 45 days, I just know I have two basically week-long trials coming up in the next month and a half. Perhaps actually 3.
Defense have any objections to that?
I don't have an objection to that. No, Judge. My only concern is, and I filed a motion to remove day reporting for him because he's still paying $6 a day. And by my calculation at this point, he would owe well over $5,000 if convicted of anything, even an amended charge. So he'd owe $5,586. So I just think that's a lot of money. So if this case is going to go on longer, I guess I would just ask the court, the motion I filed detailed that he, as of the last day report, he had 3,573 alcohol tests. Each and every one of those was negative. It looks like he had a few or several missed tests or late tests during that time period, but they were few and far between. And there was one violation report that was they reported followed up on, indicating that it was due to environmental causes and not due to alcohol consumption. So by my calculation, he said no positive tests, and the money is adding up quickly.
What's the state's, well, are we in compliance with Marcy's law on the bond motion that was filed today, I believe?
I mean, we're in compliance with Marcy's law as to notice of hearing as it relates to the bond motion. I don't know. I mean, the bond motion is that purely to address the sober link?
Yes.
Okay. I mean, can I say technically that the victim had noticed that this was going to be a bond hearing? I can't say that because it wasn't set as a bond hearing, but
Do the bond hearing, when can we get notice to the victim on the bond hearing?
I mean, you can probably, if you put it on in a couple of days, I'm sure you could, or by Friday or sometime next week, you could probably deal with it then.
Attorney Hoff, do you have time Friday?
I'll make time Friday, Judge. I wasn't clear whether the sober link was directly related to the OWI charge, which is what I thought, or related to the DC charge, but I don't know if there's a Marcy's Law issue with that.
Yeah, I don't want to parse it that way if I don't have to.
Okay, fair enough. Judge, whether it's Friday or next week, I guess, isn't a huge fact. I mean, it's $6 a day. But if it's next week and that works better for yours and Attorney Scape's schedule, that's fine with me, whatever works.
Attorney Scape, we have the hockey matter Friday afternoon at 1. Do you anticipate a resolution in that case?
Look,
Or can I put this there? Maybe I should just ask you that on a short bond motion.
let me take a look. You can probably put this there and it'd be fine.
Attorney Hawk, can you do 1 o'clock Friday?
Yes, Your Honor.
Right, that's when we'll do it. July 1st, 1 o'clock, to hear the bond motion. For the state's response to the motion for sanctions, and that's what I'm going to call it, because I think that's what it is. August 15th, Attorney Hoff, when do you want to have a reply by?
Could I do by September 5th? I think that's Labor Day. Or
6th.
6th, okay. Thank you.
And Attorney Scape, you and I have jury trials every single day in September.
Yep.
But my sense would be to put this on for decision. We could do September 16th. I can't do September 16th. I take that back. September 22nd at 1 o'clock, Attorney Hall.
Judge, I'm at a trial in branch 3 from the 19th through the 22nd, but I have the following week pretty wide open. I don't know if the court has anything there.
I have a misdemeanor trial on the 23rd. Can you do the 23rd?
Yeah.
If,
Assuming the trial is done by then, yes. But it's
1
supposed
o'clock,
to.
1 o'clock, September 23rd.
Okay, thank you.
Okay, thank you. Off the record in that case.
Judge, what was the state's deadline on that last case?
State's brief is due State's brief was due
August 15th.
August 15th. All right, I don't know where DeAndre Tremaine Smith is. He's not on, so we'll move on. Zachary Dirksen,
Yes.
move to your case next. Go on the record, please. Court calls case 2022 CM 200, State of Wisconsin versus Samuel John Edward Cups. Appearances, please.
State appears by Grant Scaife.
Attorney Dirksen appearing on behalf of the defendant. Attorney Dirksen appearing by Zoom, and the defendant also is.
All right, and Mr. Cups, are you there?
Yes.
All right, good morning. Attorney Dirksen, where are we at?
We have recently received discovery in this case and would ask for a date to be set out so we have time to review discovery and also to discuss an offer with the state.
Dave?
That's fine.
August 3rd, 1:15? Actually,
August 3rd at
1
1:15, that works.
Actually, August 3rd, 1 o'clock would be better.
Okay, August 3rd, 1 o'clock.
All right, good. Go off the record on that one. Need a moment, and we'll move on to Attorney Sarvan Singh's case. Let's go on the record, please. Entree, Tremaine Smith, we got. Ben, are you there? Benjamin Locken? Reporter? If the court reporter will be able to go. Ben, are you there? Ben Locken, court reporter. Frank, can you hear me? Or am I missing something?
Yeah, I can hear you.
There's Ben. All right, let's go on the record, please. All right, court next calls case 2020 CF 511, State of Wisconsin versus Paul David Eller. Appearances, please.
State appears by Grant Scaife.
Sarvan Singh appears on behalf of Paul Ayler, who appears, I think, by phone, Judge. Good afternoon. Good morning.
Hi, good morning, Mr. Earl, are you there? I don't see him. You want to give him a call, Attorney Singh? I can move on to Mr. Smith and we can just have him come on. We're running behind, obviously.
I thought that was the 920 number of his, but,
Nope. At the 360 is me.
oh, okay.
Yep.
Okay,
We'll go
Judge,
off
I
the-
can,
Yeah, we'll go off the record, try to get a hold of him if you could, please.
okay, we'll do.
Thank you. All right, so let's do Smith next. Back on the record, please. Board calls case 2022 CF 242, State of Wisconsin versus DeAndre Tremaine Smith. Appearances, please.
State appears by Grant Scaife.
Smith appears in custody by Zoom video and audio from the detention center. Mr. Smith, can you hear me?
Yes, I can hear you, sir.
All right, so Mr. Smith, last time we were together, you were with counsel who had to withdraw due to conflicts. And actually, I think we might have had one hearing since then. I take that back. We were together on June 13th, yes. Attorney Barrett withdrew due to a conflict. You indicated that while you qualified for a public defender, you want to get your own lawyer. We currently have a jury trial set August 4th. I set this out to see where you're at relative to counsel. I do not have any notice of retainer from anybody, so where are things for you, sir?
Yeah, I retain attorney Avery Goodrich, Your Honor. So I don't know why it's not showing up on CCAP or whatever, but he's already been paid and he went and talked to my mother, but he haven't came and talked to me yet. But I let him know of the 90-day speedy trial that I have and when my court date was and that I wanted to still keep it.
Okay. Let's go off the record for a second. I'll see if I can get a hold of Attorney Goodrich. Megan, do you have Goodrich's number?
Yeah, I can find it, Judge.
Try to give him a call.
Sure. I got his voicemail, Judge.
Hey, word, Megan?
Got his voicemail.
All right, let's go back in the record, please. All right, we're back in the record in DeAndre, Tremaine Smith. So, Mr. Smith, all we're basically doing is waiting to see what happens with you privately retaining Goodrich. I can't explain. I've tried to had Megan call his office. I can't explain it. But it puts us in a little bit of a jam time-wise. You had demanded a speedy trial. You don't have a lawyer. Your lawyer withdrew. We need to get your new lawyer on board so you can keep your trial date. And I understand you can't file a motion on behalf of your lawyer to come into the case, but I can't either, and neither can Attorney Scaife. So my sense is to set this out, have my judicial assistant try to get a hold of Attorney Goodrich, figure out what's going on, and maybe just put this Friday. I'm really worried about time passing too quickly here for you, just so we can make all efforts of having, this case addressed. I don't know what else to tell you. That's basically what we're left with right now.
Yeah, I know I had court at 10:45. It's already an hour past that, so maybe that's part of the issue. But as of now, I don't understand why he wouldn't be answering either, because he's already retained.
Yeah, he wasn't here. I can tell you that. Very familiar with Attorney Goodrich. Attorney Scaife, my sense is to put this on $2:00 Friday. We have another matter with Attorney Lacombe, but it is what it is.
Sure.
And then I'll have my judicial assistant try to get a hold of Attorney Goodrich. He was not on. I'm very familiar with Attorney Goodrich. So he represents people in my court all the time. So, and maybe you can, on your end, DeAndre, you can have your family put some pressure on him to communicate with us. Okay.
I definitely will, Your Honor.
Okay? All right.
Yes.
And then for now, we'll see you Friday, Attorney Scaife. Anything else we can do now?
No.
Okay, so we'll go off the record. Thank you. Thank you, DeAndre. So have your family get a hold of him.
All right, thank you.
You're welcome. Attorney Singh, any luck yet?
No, Judge, and I think there may have been some confusion on Mr. Ayler's part. I think because he believed the case was closed. We had communicated, and I told him I had this hearing. I don't know if he understood it as a mandatory appearance. I may have even told him that the court is going to be rendering an oral decision, and I don't know for sure. but I may have said that that's something I'd be able to cover and wouldn't require your appearance. I don't know if I did say that or not, Judge, and that may be on me. But I've tried reaching him. I've been in constant contact with him, but I can't seem to get a hold of him right now.
Right. Attorney Scape, any problems? We just have Attorney Singh get a hold of my JA and reschedule this. So I think Mr. Eller has to be here.
Yeah, it doesn't matter to me. That's fine with me. This case has been obviously closed for a while, so that's fine with me.
Well, but we are going to go. You want? I'll send I prepared so extensively. I may be writing a letter if I get time to the parties, but I can't tell you what it's about. He's not here, and I don't want to get into that. So I'll probably do a quick letter. Attorney Singh, get a hold of my judicial assistant, please,
Sure.
because I know with your calendar, and you have to get a hold of your client, make sure he's available. So call Cassandra. She's great at scheduling.
Okay.
All right?
Will do, Judge.
We won't call it then, Megan.
Okay.
Say court, defendant not notified, court to reschedule on the minutes, please.
Okay.
Or something like that, whatever Attorney Singh is comfortable with. Just confusion as to defendant's, appearance and court will reschedule. That's what we'll do. All right, thank you, Attorney Singh.
Thank you, Judge.
All right, let's go on the record, please. Court calls cases 2021 CM 381, 2021 CT 54, 2022 CF 259, State of Wisconsin versus Dustin Scott Lecker. Is Mr. Lecker in custody? Oh, Attorney Capino, you're not coming through. Let me follow up and get him from the DC, okay?
Okay, and can you hear me now?
Yep.
He is in custody.
All right, let me see what I can do. We'll go off the record. We will be bringing him over momentarily.
Thank you.